So Will, I had a question come in on one of the YouTube videos, and I thought it's a bit too technical for me. So it was a question essentially where the parents were separated, and the question was, in effect, which child does the parent reside with, and in theory, could both parents have shared dependence of a child, if that's the right word? So would both parents be in priority need, and could both parents suit the adequate number of bedrooms for that child if they were living in different days of the week or whatever? So hopefully I've kind of done justice to the question, but do you want to just kind of talk a bit about that?
Yeah, so the issue is where a family of parents are split up and the children live with them both, but both part of the time. Yeah, so the obviously the policy and resources pressure on the local authority is to say no, only one at a time, which is very distressing to people because it's a very common question: is my children stay with me, and I need to have a place that's suitable for them to stay. But unfortunately, the rule is they can only reside with one of the parents. A child can only have one home where they reside. And then the question is, well, how do you determine that? And it really does come down to a simple test of who number of hours or days in the week. So you've got 7 days a week. If the child lives with parent A for 3.6 days a week, that's where they reside. And the rest of the time they just got stay in contact with the other parent as the legal term for it. But the one way round this, because you never in practical terms, you never got a situation where it's exactly 50-50. So you couldn't say, well, it doesn't reside there more. And in the case which went all the way to the Supreme Court, or the House of Lords as it then was, in 2009, a case called Holmes Morehouse v Richmond upon Thames, the family got an order in the family proceedings, which had decided where the children live, that they would have joint residence, which in legal terms, joint is a word that usually means sort of one. So if you've got a joint tenancy, both tenants are full tenants, so stuff like that. So they were quite excited by this in terms of the housing implications, and that's where it went all the way to the House of Lords, because the council said no, and they went challenging all the way up. And unfortunately, the House of Lords said that they didn't decide, I suppose, who the child lives with, even if it's 50%. They said when a court in family proceedings makes a shared residence order and one parent is homeless, a housing authority was not obliged on account of the order to regard that parent as the person in priority need. So I think if the parents had 50-50, as in that case, I'm not sure how it works in practice, and the council said to the mother, and it's usually the mother they live with, we think in reality they live with you and they stay with their father, or the other way round, and we're going to treat one of you, the other one couldn't necessarily challenge it other than to say it should be me. They couldn't say we should both have it. And also the Supreme Court gave a little telling off to the family court, and they said a family court shouldn't use a residence order as a way of putting pressure on a housing authority to allocate its resources. So that's the answer to that one, in the sense that if you've got two children, you have split parents, then they can only live with one of the parents. But one little hope there, and I'm sure somebody from local authority might think that this was an abuse of the system. And I suppose if a lawyer advised somebody to change their plans so that they fitted this, it might be. But if you have two children and one child lives officially with one parent and the other one lives with the other one, you could then have both parents in priority need, but they'd only, in terms of suitability of accommodation, they would only have an entitlement to say, my household is one child. But nevertheless, you could then have accommodation which your children could stay at, although arguably maybe not comfortably together. But that's better than nothing, I suppose.
And I was just going to say, because it seems like what I've seen a lot with local authorities is that their only inquiry into this will be who gets the child benefit. And as if I understand that correctly, that's not, that's technically, that's not the full, that's not the full kind of question to be asked, really.
No, I've had that in a few cases where they'll say, aha, you don't get child benefits, so you haven't got a child residing with you. But there are often issues, particularly when children reach 16, and sometimes housing benefits stops when it shouldn't stop, and they've never got around to renewing it. And so the argument there is that whether a child resides with you is a question of fact, and whether you're unfortunate enough not to have claimed all the benefits you're entitled to is not the determining issue. There's one thing I would add to this subject, which comes up quite a lot, and in fact, I got approached by somebody only today about it, is a lot of people who are in the process of having a dispute over contact, over where the child lives, are caught in a catch-22, because they go to the family court and say, I'd like my child, I think it's in my child's best interest to live with me, because the other parents, live in the Vida Loca or something, and I'm worried about the child. And then seriously, I mean, you could have a situation where that happens, but then they get knocked back and they say, well, you only got a bed sit, so you can't offer your child somewhere decent to live, so we can't consider you. But if you remember, the test of priority need is whether you have a child living with you or might reasonably be expected to have a child living with you. And so you could say to a local authority, I need you to consider me as being in priority need, because I might reasonably be expected to. And I've got, in the case today, for instance, the potential client said that and you often get this, that these social workers dealing with the family proceedings are based in a different borough to the one he's applied to. And so the social workers have been contacting the housing people and saying, look, we really think you should help. And so that would, if they said, no, you're not in priority need, he'd have a good legal challenge.
Yeah.
The danger is they could review that, I think, again. If they said, yes, you're in priority need, they could probably keep him in temporary, which might not be suitable until the outcome of the court case was known. But that's something you shouldn't rule out.